much. It's great to be in Oklahoma City. I'm a flatlander myself. I grew up in Amarillo, Texas, which is pretty close and a lot of similar weather like we're experiencing today, and in the summertime when it's hot and dry and windy as well. It's really nice for me to be in Oklahoma City. I was just talking with Archbishop. Some of you may know what a magnificent archbishop. He's not an average archbishop in the United States, in the American church. He's above average, so you should be very happy about that. But way above. One of the things I love about Archbishop Coakley is when the President Obama, speaking of religious freedom, pronounced what was called a misnomer, the contraceptive mandate that required every employer to cover in their health plan contraceptives, abortifacient, sterilization, and counseling, things that don't go over too well with Catholic employers. We formed something called the Catholic Benefits Association, which today has 40% of the dioceses and archdioceses in the United States. I'm pleased to say about 80 dioceses and archdioceses, a total of 1,400 Catholic employers. And we formed in Oklahoma. And the reason we incorporated right here in Oklahoma is this is a state that's very friendly to religion as a matter of your laws. And we incorporated here, and Archbishop Coakley, I think, was one of the original 4 archbishops to serve on the board. He's the vice chair of that organization. And today we have a total of about 1,700 Catholic employers, including hospitals, colleges, charities, for-profit businesses. I remember there's a network of nursing homes here in town. Is that owner of the nursing homes here by any chance today? And so one of the things we've done in this strategic litigation is that we have filed lawsuits wherever we think we choose the location based upon a more likely that we'll have a court that is open and friendly to the religious liberty arguments we're making, and that the circuit court above it. So you're in the 10th Circuit. The 10th Circuit that at that time had a very favorable decision for Hobby Lobby, headquartered right here, and we've represented them as well, by the way. And we filed in Oklahoma City and had excellent results beginning right here in Oklahoma City. So it's really nice to be here. Now, religious liberty, I would love to talk to you for a week-long program, but you haven't given me a week to talk about why religious liberty matters. So I assume many of you already get that. And my one-page handout are my 10 reasons why religious liberty matters. So you can read that later. I'm not going to talk about that today, but I hope that you will be empowered after this talk and encouraged to talk to friends and neighbors and write letters to the editor and wherever you have access with trade association groups and others to be an ambassador for this important freedom. So that's the why you have a handout. So we're going to do a little bit something unusual today, and you have to listen closely because there's a quiz at the end. I entitled this talk Then and Now. And what we're going to do is we're going to take 2 or 3 cases from the 19th century that I'm going to tell you about and how they were decided. And then I'm going to take 2 cases from this current period that we're litigating in my law firm and tell you about those. And then I'm going to ask you, what do you think is there a difference between the way the courts reacted to those 4 or 5 different cases that I'm going to give you? So let's dive in. The first case is, and Professor Michael Scaparlanda may know this case, it's called People versus Phillips. Have you ever read that one, Michael? Have you taught that one? No. Okay. People versus Phillips, 1813, New York. The chief judge is Mayor DeWitt of New York City. Here are the facts. Back in 1813, someone stole property in New York City from a man named James Keating. Keating, no relation, I trust. Keating complained to the police and accused Daniel and Mary Phillips of being the thieves. They all belonged to the same parish, by the way. The district attorney believed Keating and filed charges. He didn't know if it was Daniel or Mary, so he filed criminal charges against both of them. Before the trial was over, Keating informed the court that the stolen property had been returned to him by his pastor at St. Peter's Catholic Church, Father Anthony Coleman. Any good German Catholics here with me besides me? Are there some German Catholics here? Those are the best kind of Catholics, right? Father Coleman told Keating, the victim, that he's going to return the stolen items, and he did. And he says, but I'm acting as an intermediary for an unnamed penitent. So the district attorney, whose proof was lacking, subpoenaed Father Coleman to testify at trial regarding the name of this penitent who had returned to him the stolen property. During the trial, Father Coleman politely declined. Now, this is in 1813. He politely declined to testify, as he had learned the identity of the thief when he confessed his crime while making his confession. Here's what Father Coleman said, and I quote, "If called upon to testify in quality of a minister of a sacrament, in which God himself has enjoined on me a perpetual and inviolable vow of secrecy, I must declare to this honorable court that I cannot. I must not answer any question that has bearing upon the restitution in question, and it would be my duty to prefer instantaneous death or any temporal misfortune rather than disclose the name of the penitent in question." I say to this day to people who don't get what Catholics are about, that what we agree upon more than anything else is the inviolability of the seal of confession. I don't know a priest who would violate that, frankly, and I've never heard of a priest who would violate that. So that was Father Coleman's testimony. What's the legal issue? It's this. Given the general law that all who are subpoenaed must testify, we couldn't have trials without people answering subpoenas. That's the general law. Can a Catholic priest be exempted from this law because his church binds him to perpetual secrecy of the confessions of the faithful? Now, let me make this matter a little bit more difficult. In 1813, there were no American precedents on point. The First Amendment had never been applied against any state law. There was no New York statute protecting the priest-penitent communication. And while the New York Constitution protected the free exercise of religion, it was pretty broad, and it had never been interpreted specifically to protect this right. So here's what the court reasoned. This is a part of its rationale, and I'm quoting from the opinion. A little florid language you'll see. When a man, under the agonies of an afflicted conscience, applies to a minister of the Almighty, lays bare his bosom filled with guilt, and opens his black heart filled with crime, and solicits from him advice and consolation. In this hour of penitence and remorse, and when this confession and disclosure may be followed by the most salutary effects upon the religious principles and future conduct of the penitent, and may open to him prospects which may bless the remnant of his life with the soul's calm and sunshine and heartfelt joy, without interfering in the interests of society. When all that's there, the judge said, surely the establishment of a rule throwing all these pleasant prospects into shade and prostrating the relation between the penitent and the minister must be pronounced as heresy under New York law. That was the court's reasoning. Case number 2. Now you got to remember these. Remember the quiz coming. 1888, Ohio Supreme Court. The case is called Mannix versus Purcell. Professor Scaparlando, do you know that one? See, I just love this. Mannix versus Purcell. John B. Purcell was the Archbishop of Cincinnati. He was one of the great Catholic bishops in American history. Consecrated bishop in Cincinnati in 1833, when the city had 30,000 inhabitants and one Catholic church. He was responsible for the entire state of Ohio. He reigned for a long time. When he died 43 years later, the then Archdiocese of Cincinnati had 150,000 Catholics, 150 diocesan priests, 50 religious order priests, a fine cathedral, 40 parishes with schools serving 20,000 students, a seminary, a Catholic college, a Catholic cemetery, and much more. And his brother had helped him do all this because he, Father Edward Purcell, was the vicar general of the diocese. It was a brother team that helped that church grow. Well, in addition to their pastoral duties, the two brothers operated a bank. they accepted deposits from the Catholic faithful who had distrusted the national banks during the Civil War. In time, the bank's debts grew to $3.5 million, for which John Purcell had pledged his personal guarantee and liability on those, but his bank had only $2.5 million to cover the obligation, so the bank was insolvent. When you're insolvent, then there was a common law remedy called assignment in insolvency, which is like a modern day Chapter 7. As you know, in Chapter 7, what happens when you file a Chapter 7 is essentially the trustee takes control of all your property and he tries to liquidate it as much as possible, and he gets a pool of money together and then he distributes it in a fair manner among the creditors. That's what happened under the common law as well. Well, Archbishop Purcell held the property of the archdiocese and all of its parishes and schools and the cemetery in the name of John B. Purcell. Not Archbishop John Purcell, not Archbishop John Purcell and his successors, not Archbishop John B. Purcell and his successors as charitable trustees for the use and benefit of the archdiocese and the parishes, just in the name of John B. Purcell. So you see where I'm going. The creditors of the bank thought, we want the assets of the one who's liable, those being John Purcell. Okay? What's the legal issue? The legal issue is this. Given that the title to all the church property was in name of John B. Purcell, is it available to pay the debts of John B. Purcell and his bank? The Ohio Supreme Court ruled it's not available. Here's the reasoning and part of that court. And I quote, "It is no innovation upon the law of evidence in determining questions like the one at bar to call in aid of the civil tribunal upon the law of the particular church involved for the purpose of determining the title to church property. It is surely not unreasonable to hold one of the great prelates of the Church of Rome to the terms upon which, by the very law to which he has vowed his fealty, he has consented to accept the legal title to property which is appointed to the uses of the church, to whose service he has with most solemn unction dedicated his life." Those assets are not available to the creditors. As a bonus, I'm going to give you a third case from the 19th century, one of my all-time favorites, called Order of St. Benedict. You have Benedictines here in Oklahoma. Order of St. Benedict versus Steinhauser. Father Augustine Worth was a Benedictine at St. Vincent's Abbey in Latrobe, Pennsylvania. Melissa, we have a dear friend there. And he was a successful writer, and he had copyrights to his name, and he received royalties during his life. It was all in his name, the royalty checks, the copyrights, it was all in the name of Father Augustine Worth. When he died, his nephews and nieces, he died intestate without a will. His nephews and nieces were his heirs, and they thought, this is all this poor priest has. He has copyrights and royalty income. We want it. They filed suit against the Order of St. Benedict. The order won. Here's the reasoning of the court, and I quote, "The monastic brotherhood known as the Order of St. Benedict was established by St. Benedict," this is the United States Supreme Court, "using the rule of St. Benedict as the decisional law for the case. The monastic brotherhood known as the Order of St. Benedict was established by St. Benedict in the early part of the 6th century in Subiaco, Italy, whence it spread over Western Europe. It was brought to the U.S. in 1846. The members of the brotherhood follow what is known as the Rule of St. Benedict, a collection of mandates essentially unchanged from the beginning. The vows are those of obedience, stability, chastity, and poverty. Poverty, which of course means a monk of that Order of St. Benedict doesn't own that, and the heirs did not receive that. The abbey kept those royalties and those copyrights. Now, jump forward to the present, okay? We have a boutique law firm in Colorado Springs. We do religious liberty work, and we serve religious institutions all over the country. This is a case called Pastor Paul Elder and the Christian Growth Center versus the city of Pueblo, Colorado. The Christian Growth Center is a small Pentecostal congregation with a heart for the poor. Everything they do is about serving the poor and teaching people about Jesus. For more than 30 years, it has hosted, in the Pentecostal tradition, evangelists who preach revival and travel a circuit in their RVs. St. Paul walked, the modern St. Paul travel in RVs, and they depend upon the love offerings of the congregations where they do their retreats. In other words, they're very poor. For 30 years, the Christian Growth Center, like most of these Pentecostal congregations, has had an RV hookup on the church property to provide hospitality to these evangelists and to help them with their living expenses. In the spring of 2021, the city of Pueblo, which has principles, commenced criminal proceedings against Pastor Elder, who, by the way, was a chaplain to the police department as a volunteer, and they brought criminal action against him and the church for violating its sacred zoning code, and thereby subjecting Pastor Elder to imprisonment and the church to fines of $1,000 per day. To vindicate his religious liberty rights, he has so far wagered $660,000 of accumulated fines in this case. The issue is whether a federal statute called RLUIPA in my house, or the Religious Land Use Institutionalized Persons Act, which functions a lot like the Free Exercise Clause, and the issue is whether RLUIPA required an exemption from Pueblo's zoning code for the benefit of Pastor Elder and his church. Mayor Gradishar, as the case was winding forward, compared the church to a meat packing plant, and we have principles, we have zoning codes, and we need to enforce them. Notwithstanding 30 years, we've ignored this, and there's never been a problem. The City Planning Commission was essentially the trier of fact, and after we put on a very excellent case giving the history of St. Paul, likening the traveling evangelist to St. Paul visiting the Roman Empire. And we had widows of evangelists testify about how this hospitality was life-saving to them, and on and on. The city attorney rose and said, we're not going to cross-examine anyone. We're not going to put on any evidence to rebut this or the importance of our interests. This is an important matter, and we need to now go into executive session so I can advise you commissioners, the triers of fact, regarding what the law was. After he finished, they ruled against us with no evidence, no contrary evidence whatsoever. City Council did the same thing, same attorney, and that's where we ended up. Final case. Both of these are ongoing. Dr. Barbara Morris versus Centura Health. Dr. Barbara Morris, a Jewish physician, is a medical doctor specializing in geriatric medicine. She was employed by St. Anthony's Hospital in Denver, Colorado. St. Anthony's Hospital is part of the Catholic Health initiatives that merged with Dignity Health to become Common Spirit Health, which is the largest network of Catholic hospitals in the United States. It has 140 Catholic hospitals, 1,000 care sites, 150,000 employees serving in 21 states. In 2016, Colorado, enlightened state that we are, enacted the End-of-Life Options Act that renamed physician-assisted suicide. I love saying that, as you'll hear why in a moment, physician-assisted suicide, as medical aid in dying, and made it legal so long as certain procedures were followed. Dr. Morris's contract with St. Anthony's, like most physicians working for Catholic healthcare in the United States, required her to provide services consistently with what's called the ERDs, the Ethical and Religious Directives, pronounced by the Doctrine Committee of the USCCB and approved, if I'm right, by the entire body of bishops. Am I right? About that. So she was subject to the ERDs. The ERDs, Melissa, my wife, who does a lot of religious teaching and writing, told me that Catholic end-of-life ethics can be reduced to no fair pushing. And that's Catholic teaching, end of life. We travel with people, we do palliative care, but we don't kill patients as Catholics. That was St. Anthony's policy as well. In August 2019, Dr. Morris qualified a man named Neil Mahoney, a patient with terminal cancer, for physician-assisted suicide, and then she promptly told the management of the hospital what she had done and what she intended to do. St. Anthony's fired Dr. Morris for violating her contract. Dr. Morris sued St. Anthony's for wrongful discharge. We promptly filed a motion when she did this that raised 4 different constitutional arguments: the First Amendment doctrine of church autonomy, the First Amendment free exercise clause, the First Amendment doctrine of expressive association rooted in the free speech clause, that we have a freedom to control what the speech of our physician is regarding something that's important, and then a novel claim based upon an article written by Mark Rienzi called the 14th Amendment substantive due process right not to be compelled to assist with killing another. The issue was whether any one of those constitutional defenses might permit a Catholic hospital to contract with its employees and require its employees to do their work according to Catholic healthcare ethics. The court ruled no. It ruled against us. It said that adjudicating this case doesn't involve any constitutional issues. Nussbaum, you raise all these constitutional arguments. They're not here. This is simply a matter of what does the end-of-life options mean, and there's no constitutional issues whatsoever, the court said, similar back to what we had in Pueblo, right? Where the court said, we the state, or we the city can't weigh our lupa. That's federal law. We just look at our local law. And then for good order, the court imposed a gag order on me and my partner, which said that we may never again in his court use the phrase physician-assisted suicide, not in writing, not in speech. I'm not supposed to say physician-assisted suicide. You see, I'm not supposed to say physician-assisted suicide. Physician-assisted suicide is illegal for me to use that phrase. Now, quiz time. Why the different approaches? 2 eras of time. Who wants to offer a theory? Why are the judges? Do you see the different approach between the earlier cases and the present case? Why the different approaches? Everybody flunks. Not one person raising your hand. I'll offer you a couple of theories. One is the massive press coverage of and the continuing cultural and political exploitation, I believe, of the Catholic sexual abuse crisis. That's a real crisis, but it's largely been addressed for 40 years. It's largely been addressed for 40 years, and Catholic ministries are the safest place to have kids today. But that's still exploited, and that has affected the credibility of the church. Second theory, maybe it's just good old-fashioned anti-Catholicism. It's out there. It's out there. I want to suggest to you a third theory, and I think there's a lot of things at work. The third theory, ignorance. Ignorance. Let me, and some of this came to me reading a very recent article in First Things by the Archbishop of Sydney, Australia, Archbishop Anthony Fisher. He told a story when he was a college student of going to the Uffizi galleries in Florence. And he spent a full day touring the galleries, and he ran into another college student, and they toured together. And at the end of the day, the college student that he had just met said to him, "Why is that woman holding a baby showing up in so many pictures?" That's a college student. A federal judge in Colorado, in conversation with me, a friend of mine, said to me once, "Is Martin Luther named after Martin Luther King?" I mean, it's just ignorance. It's just ignorance. Archbishop Fisher goes on to explain in his article, most people in the Netherlands today have never visited a church. Never visited one. Those who do believe, he says, count religion and count religion as important in their lives now represent just over half of the Americans. Now, that's the empty cup. The full cup is it represents half of the Americans. So we have to remember we're not alone, but half of the Americans don't do church. They don't do God, if you will. A quarter of Canadians don't. Only a quarter of Canadians do church. Only a fifth of Australians. Only a tenth of Britons and French and Germans. And well below 40% of American Catholics attend Mass each Sunday. In Germany, that's 10%. In France, 5%. In Holland, 3%. The elites are even less religious, though, than those average statistics, if you will. These statistics skew even more non-religious in blue states, among Democrats, and among elite groups, and even more so among judges. Even more so among judges. Judges are less religious. The CISC study that came out in 2018 found, after looking at every single published federal court and district court and appellate court decision from 1986 to 1995, it found, and I quote, that the single most prominent, salient, and consistent influence on judicial decision-making was religion. The religion in terms of the affiliation of the claimant, the background of the judge, and the demographics of the community. Stunning. That's all kinds of cases. That's not just religious liberty cases. One of the things that we did with Archbishop Coakley's help with the Catholic Benefits Association, we filed 2 lawsuits against right here in Oklahoma City for a national group of Catholic ministries against the contraceptive mandate. Not trying to have the mandate declared unconstitutional, but just saying, please, kind judge, might you let these Catholic organizations provide health care benefits to our employees? That's important to us as a religious value, but we don't want to include the bad stuff. We don't want to include, certainly, abortifacients among the bad stuff. Might we be permitted to do that? As you know from the marquee cases, again, one of which is in Oklahoma, the Hobby Lobby case and the Little Sisters of the Poor case, there were 104 lawsuits in total filed seeking religious relief, religious exemption from those mandates. Virtually every district court judge reached a ruling. Virtually every one of those 104 cases made it up to their region's appellate court, where there's a 3-judge panel, and almost all of them weighed in. So we have at least 300 judges in this laboratory of how religious freedom works in America that ruled on whether the federal statute, Father, that you mentioned, the RFRA, we call it, the Religious Freedom Restoration Act, which functions like the Free Exercise Clause, carved a religious exemption for those employers. We've yet to identify one Democrat-appointed judge who ruled for religious freedom. Isn't that stunning? Republican-appointed judges ruled both ways, more for religious freedom, but some of them ruled against it, but not one Democrat-appointed judge. So what do we do about this? What do we do? For me, it's my work to advocate for religious freedom, but I want to suggest it's all of our work. It's all of our work in the circles where we have influence or ears to advocate for religious freedom. Now, a friend of mine who's a wonderful professor at the Scalia School of Law at George Mason University, Helen Alvarez, who used to work for the bishops, who, by the way, I'm proud to say, has just this week joined our firm. Professor Helen Alvarez, thank you, wrote a book this past year called Religious Freedom After the Sexual Revolution. And she was looking at all this cascading number of mandates coming out from the states and the federal government requiring health plan coverage or performance of transgender surgeries, of abortion, and on and on and on. Here's what she wrote in her book, and I apologize for the long quote, but I think you'll find it worthwhile. Catholic institutions sorely need to change the way they speak about their refusals to cooperate with sexual expression laws. They should speak differently not only in their formal legal pleadings, but also in their statements to members, to employees, to parishioners, to clients, to patients, to students, and the public. We need to learn to speak differently about this. The responses should go way beyond a mere recitation of the religious teaching at issue. So we're used to, when we talk about religious freedom, to say, Jack Phillips' Masterpiece Cake Shop, it's against his religion to help promote with his art same-sex marriage. That's the rule, right? He can't do that. Catholics say, well, we can't do abortions. That's the rule. He says we need to go beyond just saying what we can't do, what our faith won't let us do. We need to distinguish ourselves from other service providers, and especially, talk about hospitals, colleges, charities, and so on. We need to describe what they are. We are communities responding to in unity to the call of Christ, communities called to make the living Christ present in the world. And that's a different and richer and more life-giving vision of why we do the things we do. In addition, she writes, and I quote, Catholic institutions need to articulate briefly and clearly how their observance of Catholic sexual responsibility norms is an integral part of their mission to love God and neighbor, part of the very same mission that inspires them to provide high-quality health care, social services, and education to the community, and especially the neediest. And finally, she says, with these two moves, Catholic institutions should be able to explain clearly, positively, and with enthusiasm and emotional intelligence how the Catholic approach fosters authentic love, authentic freedom, happiness, dignity, health, and equality. The very values lionized in the U.S., and for me, what I hear as an attorney, the very values lionized by the judges before whom we advocate. This is the way, she concludes, to increased respect and affection, not only for religious freedom of Catholic institutions, but for all their teachings and sexual responsibility. So here's the action steps I want to suggest to you. Number one, there's just three. Number one, study and understand your faith, especially those portions of it considered heretical in modern life. And for sure that includes at least sexuality, abortion, marriage, and human life. Study those. Understand how it fits in with the basic commands of the gospel. Love your neighbor, love God. Number two, find ways to stick your neck out a bit and teach about these issues, speak about these issues, write about these issues in a manner showing how the Catholic approach not only says thou shalt not, but it fosters an authentic love, freedom, happiness, dignity, health, and equality. So that's what I would suggest you do, and I cannot tell you how delighted I am to be here, and if we have a few minutes, I can take some questions. Okay, thank you.
We have time for a couple of questions. Anyone would like to ask Martin a question? Since you failed his test, you don't want to redeem yourself with a question? Yeah. Oh, yes, Michael.
There's one back there.
Connor was pointing to you.
So Martin, thank you. And it's actually encouraging that your take on this is that people are ignorant rather than just hostile. So that's a good.
Yeah, which would we rather deal with, ignorance or evil? Ignorance is harder in some ways. Yeah, because evil might be rational. It's wrong, but it may be rational. But yes, I think I would like to assume that most judges are ignorant, and I really do believe they are. I don't think they, think of folks who grew up never going to church. How do you even, if you feel that God hole in your life, how do you even enter a church? That place seems so other. How do you even walk in the doors of a church? Yes.
So my question, that was just a comment. Sorry.
Yeah.
My question was, you mentioned the Religious Freedom Restoration Act, which was just passed, 30 years ago?
Yeah.
Could it be, so what was the context then, and could it be passed today?
Yeah. So the context then for the Religious Freedom Restoration Act is there was a 1990 U.S. Supreme Court decision. Michael's trying to stump me, but he gave me an easier question than I gave him. Called Smith versus Employment Division, written interestingly by Justice Scalia, and it diminished the strength of the free exercise clause for protecting religious liberty. In a nutshell, that's what it did. Congress, with President Clinton and a host of sponsors, left and right, passed the Religious Freedom Restoration Act on a vote in the Senate, I think almost unanimously in the House. In the Senate, it was like 90-3 or something. Schumer was one of the proponents of it. Kennedy was a proponent of it. Bill Clinton signed it into law. And even after the court in a subsequent case called Bernie versus City of San Antonio, said that RFRA did not apply against state law, Congress says, okay, we'll pass another statute that will apply against state law. And by then, the sexual orientation community thought, oh, we can't be in favor of religious freedom. That'll be used against some of our desire to force people who disagree with us to cooperate with our choices. And so when they passed a fix to the Bernie case called the Religious Land Use and Institutionalized Persons Act, it only carved out federal religious liberty statutory protection against land use regulations and prisoner claims. Yeah, so no, it wouldn't pass today.
May I ask a question? So how much hope and optimism does the makeup of the Supreme Court, with so many of those being Catholic, give you for the future of religious freedom?
Yeah, it's huge. It's huge. And so as an advocate, first, from the data I gave you about the judges in the contraceptive litigation, One of the things we do, especially with the Catholic Benefits Association, is we choose venue that's going to be cooperative for us, or not cooperative, but the judge will be open to the arguments. The majority of judicial regions, circuits, are not favorable today. So the destination at the end is the U.S. Supreme Court, but for any cert application to the Supreme Court, on average, the likelihood cert will be granted is about 1%. But the fact that they're there, and they take more than that for religious liberty cases, is huge. It's huge. And so you have to pray for those judges, the justices, if you care about religious freedom, pray that they live long and well.